Good evening, everybody. Welcome to the USIBC and the Katan & Company Legal Digital Roundup. We have a wonderful newscast today. For those of you who have not joined this event in the past, it's really a great opportunity. We have a series of experts that are going to come forward and talk about a number of issues du jour, revolving around India's legal and regulatory environment. The structure of this all is that Paku Khan will be our moderator, and he will hand it off to the appropriate experts. We do have a series of slides. We will make those available. And as a reminder to our members, please stay on mute and stay off camera. If you have any questions, put them into the chat or raise your hand. And this is being recorded. So with that, I want to hand it over to Paku Khan. Over to you, sir.
Jay, thanks a lot. And just a quick question, is everyone seeing the slides?
I was about to share those during as you introduce them.
Okay, great. Jay, thanks a lot. So ladies and gentlemen, thank you so much for joining us today. As Jay said, we run this as a newscast format like the nightly news because we're covering a wide variety of topics in a very short amount of time. All in, we're going to try to go about a total of 45 minutes, which will include Q&A at the very end. So I'd encourage you to ask questions through the chat feature. Moving on to today's program, as I said, we're running this as a newscast, and so here are your reporters or correspondents in the field, and I'm going to quickly just introduce them to you. From left to right and then top to bottom, we have Prashant Ramdas, who is a banking and finance partner in our Bangalore office, also specializing in fintech. Next to him, we've got Shobhit Chandra, who is a telecoms, media, and technology, or TMT, partner. And he and the next gentleman, Mohit Kishore, are going to be talking about the draft Telecom Bill that you've heard a lot about, as well as certain directions. And speaking of certain directions, if we move all the way to the right at the top, we've got Anushka Sharda, who's a dispute resolution and litigation partner in our New Delhi office. She's going to be talking about some very interesting litigation regarding certain and also the right to privacy. And then on the bottom row, we have Sudipta Bhattacharjee, who is a tax partner, and he's going to be talking about something very interesting, and that's the taxman cometh regarding online gaming, and actually some very, very significant developments there. And then finally, right in the middle of the bottom, we've got Panjal Prateek, who happens to be my competition antitrust law partner, and he's going to be talking something near and dear to my heart and something that I think every one of you should be aware of, and that's some proposed changes that are quite significant to the antitrust competition law regime in India. And then that aging old fellow on the bottom left is myself. I'm actually coming to you from Berkeley, California. And with that, let me turn it over to Prashant to walk us through the RBI. Let's go to the outline first. Jay, if we can move to that slide. Okay, so basically what we have is Prashant in just a second is going to walk us through digital lending guidelines recently promulgated by the Reserve Bank of India. And then in items 2 and 3, Shobhit is going to give us a general overview of the draft telecommunication bill and certain directions. And then Mohit is in number 3 is going to give us a deeper dive into the draft telecommunication bill regarding telecom company insolvency provisions. Then at number 4, Anushka is going to take us into a lawsuit that's recently been filed by a VPN regarding certain directions. Finally, we're going to be hearing, the last 2 will be on taxation in the online and gaming sector that Sudipta is going to run us through. And then finally, the antitrust changes that I spoke about. So Prashant, over to you to talk about the RBI digital lending guidelines, please.
Thanks, Paku. Good evening, everyone. So On the RBI digital lending guidelines, the RBI constituted a working group last year, which actually spent around 8 months to kind of study digital lending practices in India, and issued a working group report recommending certain regulatory interventions which the RBI as a regulator must take. And the backdrop to the formation of the working group last year was certain dodgy practices in terms of recovery and general business conduct in the digital lending industry, which the government wanted, RBI to look into. Basis which the working group report was issued by the RBI, inviting public comments. And in August this year, the RBI issued a press release, outlining its approach towards implementation of the recommendations of the working group, which the RBI broke down into three buckets. So there were a bunch of recommendations which the RBI immediately wanted to implement. Bunch of recommendations which RBI said that they are still examining, those recommendations, and we will come back with future course of action on those. And the third bucket was the recommendations which the RBI felt the government must handle through legislative action. Right. So overall, the RBI kind of broke down the recommendations into three buckets. And in September, the RBI issued, the lending guidelines, which came out with a varied set of compliances, for digital lending players, and these are all effective immediately. So all market players, had to immediately kind of change their operational processes to ensure compliance with the regulations. I think we've set out the key takeaways of the guidelines on the screen, but I'll discuss a couple of key important issues which a lot of market players have been grappling with. I think the most kind of pertinent topic is relating to FLDG, or first loss default guarantee, which essentially is guarantee comfort or credit comfort, which unregulated fintech companies who operate customer-facing digital lending applications were providing to regulated lenders who were lending to customers of that platform. So this was a industry practice which everyone used to follow, and the working group report had recommended that the RBI should restrict this practice, because the working group felt that there was systemic risk with unregulated entities assuming credit exposure for loans which were offered, through online medium, through digital apps, and the sector, really boomed after COVID as well, and there were a lot of market players, a lot of apps which kind of started offering buy now pay later products, consumer durable financing products, as well as other type of financing products for businesses as well, including anchor based financing, cash flow based financing, revenue based financing products. So overall, I think the industry relied on two distinct set of players: regulated lenders, which are banks or non-bank financing entities on one hand, and service providers, tech service providers, who operated the lending apps and provided onboarding services, loan portfolio monitoring services, as well as collection services to those lenders. So RBI obviously does not have jurisdiction to regulate the service providers, but the RBI is regulating the banks and NBFCs, and has restricted banks and NBFCs from getting FLDG comfort. And RBI has said that they are viewing this akin to synthetic securitization, which is where the exposure remains in your books, but you hedge that risk through credit guarantees, which is not permitted in India. So the RBI has clearly kind of implemented the working group's recommendation and has put its foot down on FLDG arrangements, which is a major impact to the digital lending industry, because most of the platforms source customers and refer customers to the lenders, and lenders do expect some skin in the game from the fintech companies operating these platforms. And that's really something which the industry is right now grappling with, and looking for solutions and alternate structures to give comfort to lenders participating in lending through these platforms. Apart from that, the RBI has also kind of focused a lot on data collection and storage practices followed by fintech companies in India. The RBI has restricted companies from accessing mobile phone data of customers and also introduced data localization requirements for the digital lending industry. And I think these are some of the key points which RBI has introduced under the guidelines.
Prashant, thanks very much for that. Let me ask you a question. Generally speaking, in your view, do you believe these guidelines are in line with international norms from other countries? And the second question that I would have is, what's your feeling about this? Is this purely a consumer protection type provision, or are there business opportunities that might arise out of these digital lending guidelines?
So I think on the first question, Paku, I think these are definitely customer centric. And when you talk about comparing this with international best practices, RBI has introduced these guidelines and which lend some legitimacy to the industry as a whole. A lot of investors and companies alike are looking at India as the next big opportunity, for fintech as a whole. And given the population, the penetration of smartphones and internet in the country, this is really the hotspot, for various suites of financial services, including digital lending. In terms of whether these are in line with international practices, yes, these are consumer centric. These protect consumers, but RBI has also kind of gone a step overboard with respect to some points like FLDG and usage of cell phone data for underwriting, etc. And those kind of are akin to maybe Chinese regulations, where the regulators are very strict in terms of what marketplace can do and cannot do. And definitely the focus has been on consumer protection, given various instances of harassment of consumers, etc., which were reported in the media. So the lenders need to kind of comply with a host of compliances, and which are focused on making the products transparent, and disclosing key aspects, of the products to the consumers upfront, etc.
Okay, Prashant, thank you so much for that overview on the digital lending guidelines. Ladies and gentlemen, just a couple of admin notes. If everybody except the speaker can turn off their cameras and their audio, that will help greatly. Second, we already see some questions coming in, and we'll address those at the end of the program in the Q&A session. And as Jay pointed out in the chat, the USIBC had actually made a submission on these digital guidelines. So please feel free to email Jay and the USIBC if you want a copy. So let me now turn it over to Shobit and Mohit, who are going to give us an overview over the draft telecommunication bill, as well as doing a deeper dive into the insolvency provisions of that bill, and also talking about the certain directions. Shobit, over to you.
Many thanks for that, Paku, and a very good evening and good morning to all joining in. I think to start off, I'd like to clarify that I'll break my presentation into two parts. The first one will deal with, of course, the overview of the recently issued draft telecommunication bill. And in the second part, I'll just have a very broad overview of the recently issued certain directions which have taken full effect just last week. So to start things off, the Telecom Bill, as much has been said about it in the past couple of weeks as to how it seeks to change the telecom landscape in India. Given the time constraint that we have right now, I'd like to focus on some of the key aspects that have really made an impact in these last 2 weeks. So, well, the first thing here is to note that the bill seeks to amend and supplant the law which has been there for almost a century and a half. And the current law that governs telecom finds its genesis in the provisions of the Indian Telegraph Act, which is dated way back from 1885. So it'll be a sea change to see that there'll be a telecom law that will be more recent in its date and will cover aspects that are more up to date as far as the nature of services are concerned. That, of course, has its own challenges, but we'll talk about that a little later. Another thing that the bill has sought to do is to streamline the process of spectrum allocation. That over the years has been rather complex and rather inconsistent. So the government has clearly laid down rules in terms of when spectrum would be laid down administratively, as well as when it would be done so by way of an auction. Um, Another notable change has been in the way that the consequences and penalties have been spelled out, because that has been a huge disconnect. A lot of it has got to do with the way that the law has been worded, it being a very old law till now, and the way that it has synergized with the license terms and how and the penalty schemes that have been envisaged under those. So what the proposed law seeks to do is to bring in a graded penalty scheme, which will bring in, relatively speaking, more clarity into how offenses will be dealt with and the consequences that will ensue. Um, Right of way is another endeavor that the government has tried to address. Because right-of-way permissions in the past have caused a lot of problems, given the myriad authorities that need to be dealt with, especially in the current scheme of things when the 5G rollout is ongoing as we speak. This will bring a breath of fresh air, and if this process can be streamlined in a way, it'll definitely bring a lot to a lot of cheer in the industry. Um, there are certain provisions that deal with the IBC, which my colleague Mohit will be dealing with very shortly. There are attempts made to address some past irregularities, but they have implications of their own, which Mohit will talk about. And very quickly, I'd like to say that while, of course, the law seeks to change a lot of things, I think there are still things that could have been dealt with in a probably a better way. Firstly, the way that telecom services have been defined is rather wide, and it can have vast implications in terms of the licensing requirements that are associated to that. Other things that need to be addressed are, clarity on uh, the extraterritorial applicability of this law, which, if you look at some other statutes like the Information Technology Act, there are provisions that deal with those kind of situations. That is missing in the proposed law. So it would have been nice to see something on those lines. And I think a very important aspect here also to consider is, because the government has talked about a more robust KYC as well as a lawful interception mechanism, how that will interplay with the upcoming privacy law, and especially in the current state where the privacy law does not exist in a comprehensive form. So these are questions that remain unanswered as far as the telecom bill are concerned. With that, I like to move on to a very brief snapshot of the certain directions which were issued, of course, towards the end of April in 2022. They took effect in the end of June of this year, and on the 23rd of September, they took full effect. And what I mean by that is, there were certain entities, specifically in the MSME domains, who were for whom the application of these directions were extended. So in essence, the directions speak about a few obligations, and these have been necessitated the preamble suggests that because the certain has had trouble collating information, and which would be necessary for it to carry out and discharge its functions, regarding retention of logs, user information, and basically to help them tackle cybersecurity incidents. So the certain directions speak about timely reporting of cybersecurity incidents. The type of cybersecurity incidents have also been prescribed. There are requirements to maintain logs, and more so, there's a localization requirement attached to that. My colleague Anushka would be touching upon that in the litigation that she'll be speaking on. There are requirements also to appoint a point of contact. There are requirements for assisting certain in different situations as and when required. And there are certain KYC requirements which have been prescribed for certain specific type of service providers also. So with that, I'd like to hand it over to my colleague Mohit, who will take it over from the IBC provisions. Thank you so much.
And Mohit, just before you come on, yes, I was just going to mention to Jay, I think we need to move back to the insolvency slide. That'll be the first thing. And then second of all, we still have at least one audience member with their camera on. So could I please ask them to turn it off, please? And so Mohit, over to you.
Thanks, Paku, and thanks, Shobit. I think Shobit laid down the bedrock of what I'm going to discuss. The insolvency law, which came out in 2016, was in itself a radical reform and was greatly needed at that point of time because the earlier insolvency law had failed the test of time. It was, if I can use the word, it had turned out to be useless, and therefore it was a key reform. However, when it specifically came to telecom companies, the experience was slightly difficult, and everything revolved around the usage of spectrum. In certain landmark cases, be it Aircell or similar cases, the resolution plans, which is basically the proposal for insolvency resolution of a company, could not finally pass through just because there was no clarity on whether the spectrum is an asset of the company and can be transferred through the IBC process. Now, while the model bill, or rather the draft bill which has come out, is very well intentioned and it tries to address these problems. However, what Shobit also hinted at, there are certain gaps which maybe which we wanted to highlight in this session so that everybody is aware of what are the possibilities. Now, going to those provisions specifically, now insolvency law, as most of us are aware, the idea is to create a safe space for a company, a breathing space, so to say, where a company which has gone insolvent takes some amount of time. It is protected from litigation. Its management passes over to its creditors. The creditors run a law mandated process and a new entity comes over and takes the company. And very importantly, all claims on that insolvent company prior to it going into insolvency have to be settled through the insolvency process. In that perspective, let us now look at what the draft telecom bill says. Now, firstly, the bill is very clear that if there is any default, and I'm emphasizing on the word any, if there is any default by a telecom company in payment of its dues, and that too is classified as any dues, not just current dues, any dues, then the spectrum automatically reverts back to the central government. Now, imagine a situation where that happens. There's a company which has gone into insolvency, and obviously that company has gone into insolvency. The possibility of it not being able to make its payments is very high. In that scenario, if the spectrum goes out of that company and vests with the central government, which according to the draft bill is then entitled to allocate that spectrum or even the assets of the defaulting or rather the insolvent telco to any other entity, why would there be any bids for the insolvent company as such? So that is one particular area of concern. What is essentially happening is within the insolvency safe space, the lawmakers are trying to create another safe space for a telecom company. And the bigger question is that what if it leads to a cascading effect? What if companies in other sectors, who will all have their own reasons, start saying that you have given certain additional layers of protection to a insolvent telecom company, please give that to us also. The second point of interest, and that is also very important, is that the draft bill says the insolvent company can continue to use its license only if all of its payments are parked in a separate account and that account is used in priority to all other payments to pay the past dues. Now, this stipulation itself goes against the basic tenets of the IBC, because the idea under IBC is that once a company goes to an administrator, which we call as a resolution professional, he only takes care of the necessary payments. Like I said earlier, for all past dues, you file a claim, that claim is then settled to the process. Now, if you create this superstructure, so to say, for the government dues towards spectrum or licensing charges or anything, then essentially it could be contented to be a preferential treatment in which would make it very difficult because you're creating a class within a class without any intelligible differentia. And like I was highlighting, there's another section which is also very important. The central government has that discretion, and in the draft bill, there are no objective criterias on basis of which that discretion will be exercised, but it can direct the management or even the property of the insolvent telecom company to any person or entity. Now, while I highlight these issues, let me come back and say that the intent is very noble. The intent, and it is the stated intent in the bill, that the bill aims to ensure efficient availability of spectrum and telecom network throughout the country. So those are essentially the challenges that we see with this draft bill, and I keep emphasizing on the word draft bill as of now. Paku, we may proceed to the next section, maybe.
Mohit, just a quick question for you before we move on to Anushka. At the very bottom of your slide, at the bottom left, you say insolvent telcos are governed by two arguably conflicting statutes. In 30 seconds or less, how are they going to navigate their way through these potentially conflicting laws?
I have an answer for that, and that is based on something which I think people would identify with. There's a concept in India called an arranged marriage. So basically, what the lawmakers are trying to do, they are trying to arrange a marriage between the telecom laws and the insolvency laws. And like with any arranged marriage, these are teething problems. Now, the point is, this is currently a bill. There are stakeholder negotiations going on. The news reports indicate that the last date of submission of comments is also going to be extended. So the possibility that these minor creases could be ironed out is very high when this finally becomes a law.
Great, Mohit, and I love the arranged marriage reference too. I think we all understand that. So let's move on, Jay, to the next slide on certain litigation. And certain is uncertain in my parlance, but this is a virtual private network instituting litigation in the Delhi High Court. And I'm going to ask Anushka if she can walk us through the implications of this very interesting case on numerous fronts. Anushka?
Sure. Thanks, Paku. So as Shobit mentioned earlier this year in April, certain issued directions which created quite a stir in the industry, and now these directions have come into full force. While various entities and trade associations made representations to the government regarding their concerns, it is only finally in September that the first challenge to the directions was filed before Delhi High Court by an Indian VPN service provider, S&T Hostings. Now, I must clarify that this challenge is limited only to directions 4 and 5. So while Shobit mentioned that the certain directions require a host of compliances, the challenge does not extend to all the compliance requirements and is only restricted to directions 4 and 5. Now, what is direction 4? Direction 4 essentially requires entities to maintain detailed logs of all their ICT systems for a period of 180 days, and the same are to be stored in India as per the directions. Now, interestingly, the FAQs issued by the government pursuant to the directions provide that the logs do not have to be maintained in India, and a copy can be maintained outside, in fact. However, the FAQs are stated to be non-binding, and as could be seen from the proceeding in court as well, the directions will prevail in case of an inconsistency between the FAQs and the directions. Now, the certain may call for these logs at any time, and there is no predefined parameter within the directions as to what is certain's power to call for these logs and how can certain use these logs. Of course, in the FAQ, certain has clarified that it will only be using these logs for the purposes of addressing cybersecurity incidents. The directions are, however, silent on this aspect. Now, Direction 5, which is also a matter of concern, requires various entities, again, including VPNs, to register and maintain personal user information for a period of at least 5 years post-registration, post-cancellation of the user's registration. Now, such information is fairly detailed and includes the name, address, email ID, and contact details of the users. It also includes the ownership pattern of an entity, the period of hire of such services, as well as the IP address and the timestamp used at the time of the registration. I'm going to briefly touch upon the main challenges taken in the writ petition against the directions. Now, first and foremost, the directions, of course, are argued to violate the right to privacy of the users using VPN services. Now, what the directions essentially require is for the VPN service provider to track the activity of the users online and to record each activity in its database. Further, it requires it to maintain the personal records of personal information of the users for a period of 5 years. Now, the government can demand this information at any given point of time. And it's important to note that the information needs to be maintained by the VPN services providers, regardless of whether the user's access was legal or illegal. Now, as is well known, the Indian Supreme Court has upheld the right to privacy as a fundamental right and has said that this right can only be restricted for purposes which are proportional in nature. Now, what the obvious argument is that if you require data to be captured, regardless of whether the access is legal or illegal, and this data can be demanded by the government at any time, and nor are there any limitations prescribed on the use of this data, this arguably does violate the right to privacy of users of VPN service providers. The next date before Delhi High Court is in December. It will be interesting to see if other VPN service providers also join in the challenge. And of course, whether the court does take a step ahead and dilute the directions to some extent at least.
Anushka, thank you for that. I'm going to ask you the 1,000 crore question that everyone would ask. What's your expert view on who might win this litigation in 30 seconds or less?
Paku, I think there are serious concerns with the directions. Most importantly, there is no legislative backing. There is no legal sanctity to requiring any entity to track a user's online activity and to store such vast amounts of personal information. Now, in this background, I do think while it's very hard to get the court to interfere with executive direction, especially in the tech space, which is not well understood, honestly, by courts yet. But considering the impact of these directions and the lack of legislative sanctity, there is some hope that there may at least be some amount of dilution.
Okay, Anushka, thank you so much for that. And we're going to move to Sudipta, who's going to talk about taxation on online gaming. Before Sudipta starts, just want to refer the audience to 2 comments Jay has made about USIBC's involvement in the draft Telecom Act, as well as on certain directions. So please take a look at that and contact Jay if you have additional information that you need. Sudipta, over to you, please.
Thanks, Baku. A very good morning and good evening to all of you. Online gaming has truly been a sunrise sector in India, especially, it has seen massive growth in the last couple of years, as we know, and it has not gone unnoticed by the government. While there has been a lot of encouragement, support, talk about light touch regulation from many quarters, the taxman has decided to claim a huge pound of flesh from this sector. But before that, a slight bit of context to set the background. In India, from as early as 1950s, it has been very clearly recognized distinction in terms of game of skill versus game of chance. Game of skill like rummy, poker, horse racing, etc., have been held to be games where predominantly there is a skill element involved. The outcome of the game does not turn in merely by chance, versus games of chance, which are more in the nature of pure play, betting, gambling, etc. The first category, i.e. the game of skill, has been held to be protected under the freedom or the fundamental constitutional right to trade, whereas games of chance do not have that protection. And that theory or that distinction has been carried on in the realm of taxes also, in as much as the entire online gaming sector, which was into facilitating games of skill on their platforms, they were charging 18% GST only on the usage fee or the platform fee that is levied from the users. And it is the games of chance, the gambling platforms, etc., who were liable to charge 28% GST, not only on the usage fee part of it, but also on the buy-in amount. So the total pot was being subjected to, or is being subjected to, a 28% GST. But this distinction was clearly maintained till now. What has happened in this, what is being touted as the biggest ever show cause notice that has come in, biggest ever demand that has been issued to a Bangalore-based gaming company, close to about $2.5 billion. The department is trying to take a stab at overturning, obliterating this particular difference, which has been established by case laws over a period of more than 5 decades. The argument that is being sought to be pushed is that even if it's a game of skill, if it is being played over an online platform which charges ad valorem percentage as fee for the usage, etc., and there are stakes involved, if basically all the entire real money gaming sector should qualify as betting, irrespective of the game of skill versus chance distinction, and should be liable to pay 28% GST on the entire buy-in amount. Now, as you can imagine, the sheer quantum of tax that is being sought to be recovered is much, much higher, is in multiples of the amount of revenue that has been recognized, that has been earned by many of these companies. And what the department is also effectively doing, they're trying to overturn the 5 decades of jurisprudence with this, mere argument, or the fig leaf, so to say that to assert that the GST authorities were not a party before the courts for all of those cases. GST law was something that was not in question before all of those cases, and hence we will not look at them. Hence we will sort of disregard the distinction that has been so painstakingly settled by Indian courts over all these years. The show cause notice that I mentioned, which has started this entire conversation, has already been judicial review has been sought vis-a-vis the show cause notice. In full disclosure, we are handling that before the Karnataka High Court, but I would not want to spend too much time on the specifics of that case. But what we need to understand is the industry-wide ramification of this. After this, came to light, there has been a lot of press releases from the government side where they say that this is not only vis-a-vis this one company, they want to replicate this argument and push this argument vis-a-vis the entire online gaming sector. And as per some estimates, they're looking at recovering about $25 billion in back taxes from the entire sector. But that will obviously destroy this entire sector. It is with the hope that the view of the entire industry would be presented before the court, that All India Gaming Federation, it is one of the largest industry bodies of online skill gaming platforms, they have applied to implead themselves before the Karnataka High Court. The matter is listed before the High Court on 27th and 28th of this month, and one really hopes that one gets a fair hearing, because otherwise this will be really bad news for a sector which has tremendous potential in India. And one last thing on this is, ironically, the GST Council, which is the largest constitutional or the highest constitutional authority in India vis-a-vis GST, they have been seized of the matter. They have it is on their agenda to decide what should be the correct GST treatment vis-a-vis online gaming, casinos, lottery, etc. There is a special group of ministers been constituted to that effect, but yet one might say that the GST authorities have jumped the gun in issuing this show cause notice. It will be interesting to see how the GST Council responds to this particular development.
Sudipta, thank you very much. And we are running a little bit short of time, so we're going to move to our last segment today, and that's going to be on proposed changes to the antitrust competition law regime in India. So as I said, this is the area that I work in, so it's very near and dear to my heart. And here's my partner, Pranjal Prateek, to talk about these changes. Pranjal?
Thank you, Paku. And as much as I can speak, probably you could have also spoken on this topic. But anyway, so on the antitrust side, the competition amendment bill has been laid before the parliament this August. And the bill has now been referred to the Parliamentary Standing Committee on Finance to look at the bill and scrutinize it more closely. But I would like to take up a few important changes that are sought to be brought to the Competition Act, which are likely to affect the audience here. And I think from the audience perspective here, I think the most important one here is the deal value threshold, which is sought to be introduced in the bill. And what the bill says is that any transaction wherever the deal value involves INR 2,000 crores, which is 20 billion Indian rupees, which roughly translates to around 250 million USD. Those transactions will be in addition notifiable to the Commission, in addition to other jurisdictional tests, and which were based on the parties' sizes and or the group to which they belong sizes. So to that extent, it's a game changer if this is brought into the law, because although it is meant to sort of protect against those what so-called killer acquisitions, it can have a chilling effect on those very targets that it seeks to protect. They might be left cash strapped, and given that the current economic scenario in the country, where these startups are booming and there are a lot many unicorns which are still forming, although the downturn in the economy, this can have a really massive impact for the incoming investment and when they look at potential targets. The other one important area I want to discuss was about the change in threshold of what CCI understands as acquisition of control. From the previous position where control was interpreted to mean acquiring decisive control over an entity, that is proposed to be changed to only acquiring material influence. So what that would mean is that whenever an entity acquires material influence over another entity, that in itself can become a notifiable event before the CCI. And the CCI, through its case laws, has interpreted what is the meaning of material influence, and probably just board seat or certain special contractual rights that an investor might negotiate in its investment would amount to material influence. So again, this is going to have a large impact on financial investments where perhaps there are certain investment protection rights which are borderline really in terms of any control that it probably bestows on the investor. Those cases will be clearly notifiable to the CCI, and not only in terms of notifiability, this will have an impact. Already CCI is looking at all those entities where another entity has material influence as part of its competitive assessment. So, but this will have an additional impact as far as jurisdictional thresholds are concerned as well. On the enforcement side, the bill proposes inclusion of settlement and commitments as well, which is obviously quite popular, at least in the Europe and for that matter, even in US. And settlements are for the cases which are more serious in nature. And of course, both these provisions will apply only to non-cartel cases. Settlements will apply to more serious cases where report of the Director General has come out recommending a violation of the law. In that scenario and at that stage, a party can assess for itself whether it wants to settle the case by paying an amount to the commission. At this point, it is not clear whether an admission of the guilt will be necessary at the time of settlement. And so is the case with commitments. Commitments will trigger early on when the case has been referred for investigation itself. Commitments are obviously of lesser seriousness because right at the threshold, when the CCI forms a prima facie view that a case should be investigated, at that stage a party can assess its position in the case and probably offer those softball kind of commitments before the CCI and wriggle out of the entire litigation. And that saves time for both the commission as well as parties. So welcome changes on the enforcement side. Lastly, I would want to discuss about leniency plus. This is a provision which is already in law in the United States, at least for over a decade. I don't think Europe has adopted this approach. What this essentially means is that, especially for companies which are multi-product companies or probably are active in different markets, for those companies, if they have certain reportable leniency conduct with respect to one market, they could be additionally benefited in the same case if they disclose another cartel with respect to another relevant product. And that will not affect, obviously, their position with respect to the new cartel that they have disclosed, but certainly will help, and CCI will factor that in when it looks at the first cartel that has been disclosed. So that's it from the competition side. From Paku, over to you.
Okay, Pranjal, thank you so much. And Jay, I think in the interest of time, we've had a number of questions from the audience, et cetera. Shall we just go into a quick Q&A and let you take that control?
Absolutely. So thank you. Always learning every day from our experts. Pranjal, I'm going to start with you. There's a lot of interest in the competition law. A lot of it has to do with what the parliamentary committee may do to change the report, or I'm sorry, change the draft law itself, and there's some report. What kind of insight can you share about the committee itself and its specific report? When might it be due? When might the draft bill actually be reviewed in Parliament? Is it this year? Is it next year? And of course, is there any opportunity for stakeholders to get involved?
Yeah, thanks, Jay. On that one, the bill has been referred to the Parliamentary Standing Committee in August, but the committee itself has been reconstituted in September, and that has sort of reset the entire process. But in the meantime, the good news is that the same chairperson of the Parliamentary Standing Committee continues to hold that position, Mr. Jayant Sinha. And that probably will accelerate things. And we are anticipating that probably sometime in November or early December, the report from the Parliamentary Standing Committee should be laid before the Parliament. And then that might just go through some form of debate in the late winter session, or probably then look for a passage in the early budget session next year. So that's what the timelines look like. And also, I think there's a question about, when can there be opportunities to provide inputs? The Parliamentary Standing Committee has sought inputs from certain industry bodies, including law firms. So as a law firm, we have also provided inputs on the bill. General public comments have not been opened yet, but we are hoping that the standing committee will at some stage also ask public to provide comments in a small window of 15 days or so.
Okay, great, thanks. And if you hear that window is opening, let us know, because obviously that's a short turnaround time, and I know a lot of people would want to respond to that. Thank you. Turning to SEDIPTA, I think it's really interesting that on the one hand, the government really is trying to promote gaming and the sort of new media of audio visual services. On the other side, they're applying not only taxes, but high taxes and even back taxes. It seems to me like those are juxtaposed positions. Is this a situation where maybe the left hand has an objective and the right hand has another objective? Or is there some kind of behind the scenes, policy or position there? Over to you.
So I think there is a fair amount of clash of multiple interest groups. There are many quarters within the government which feel that things like casinos, lottery, online gaming, all of that should be treated with one broad brushstroke. And of course, then there are other thoughts around this. The IT department, the IT ministry particularly, is quite positive, quite optimistic about the future of online gaming as a sector and its contribution to Indian economy. So I think ultimately we'll have to see where the dice ultimately falls. There is a bit of the right hand does not know, or there is a bit of conflict in terms of what the government is saying to encourage the policy, to encourage light touch regulation and this kind of a high tax regime. In fact, this is one of the points that have been highlighted when we have sought judicial review, that the government is sort of blowing hot and cold vis-a-vis this particular sector. But yes, there is a bit of that.
Have you heard of any impact on investors? Because I know there's a lot of money coming into that sector as well. I mean, how are they taking this? Is this sort of just par for course, or do you think it's sort of changing sentiment?
It is definitely going to affect the sentiments. I think it is still fairly early days. This is a development that's even less than like 15 days old. So I think, and the fact that we are already before the court, the judicial review is already, the process has been initiated. I think more of a wait and watch approach is being taken. But yes, this has the potential to definitely significantly disrupt investor sentiment in the sector.
Thank you. Thank you. So turning to the questions from the chat, there's one from Ashwarya on FLDG arrangements. Are they only set aside for unregulated entities? What kind of fintechs are regulated? What kind remains unregulated in India? And, just sort of, it's really talking about other fintechs that are falling into the digital lending ecosystem.
Yeah, thanks, Jay. So on that, I think the RBI only regulates licensed entities like banks and non-bank financial companies or NBFCs. RBI, under the digital lending guidelines, has not gone a step forward and required non-regulated lenders who operate lending platforms to directly register with the RBI. Instead, the RBI is regulating the outsourcing arrangements by such regulated lenders with the service providers of the loan apps, right? So fintech companies who do not kind of lend on their own balance sheet or who do not have a regulated entity within their group, they remain unregulated. And fintech companies which only kind of provide tech services to lenders, they are indirectly regulated, under the outsourcing guidelines issued by the RBI. In terms of the FLDG arrangements, I think the RBI, under the guidelines, has kind of included language which restricts FLDG both for regulated entities as well as unregulated entities. I think RBI has been very clear that unregulated entities providing FLDG, poses a systemic risk, in the ecosystem, and that's not permitted. And with respect to regulated entities, providing FLDG comfort to other lenders who are lending on their balance sheet, RBI has kind of equated that with synthetic securitization, which is not permitted in the normal course, and lenders will have to kind of have 100% capital charge accounted for, such FLDG which they provide. So it doesn't make it practical for them to kind of provide such FLDG under the new guidelines.
Great, thank you, thank you. A couple of our speakers referenced issues about privacy and localization. And, I think there's an overarching question from our community is how do the various kind of sector-specific laws that deal with privacy and localization versus what we hear is the pending privacy bill. How do we think this is going to play out? Do we think that there's going to be a shift to sector-specific regulation? Or do you think that the privacy bill will sort of supersede it and set those sort of guidelines? It's a conceptual regulatory question, but it seems like in the absence of a privacy bill, we have a lot of sector-specific laws that have actually required localization. So, whether it's CERT or digital lending or telecoms or even digital health. So how do you think this is all going to play out?
Right. No, I think in RBI's case, RBI has always stood its ground, when it comes to data localization, the context of payments data. And right now, with respect to lending data as well, the RBI has kind of widely worded saying all data, which digital lenders and lending platforms access must be stored only in India. In terms of your question on how will this interplay with the data privacy legislation, as we all know, I think the old bill has kind of been withdrawn now, and the new bill will come in the next session of the parliament. But I think even under the old bill, the requirement was only for a copy of the data to be stored locally. Unlike RBI stance where all the data must only be stored locally, and I think with respect to payments data, RBI has only permitted data to go abroad for processing purposes. And again, there are timelines and strict compliance is prescribed in that regard. With respect to digital lending data, RBI has again remained silent on the operational mechanics of what is permitted to be stored outside India, etc. And it appears that RBI is looking at strict enforcement of data localization norms, even for digital lending data.
Great. So we have a question from the audience, but before I ask Tushar to ask his question, are there any other experts that'd like to share their thoughts on that localization piece? I know 2 or 3 of us spoke about it today. All right, over to you, Tushar.
Thank you so much, Jay. I had a question on competition for Prateek. So Prateek, I have a couple of questions on competition, fairly short if you have any response to them. One is on ex-ante regulations. When we say, and CCI is looking at what's happening globally, are they taking that route, or is that a recommendation that's coming from locally? Do you have any sense on that? And how will the push for ex-ante regulations, how will that manifest in the competition amendment bill? This is one question. And the second one is that because of this, is there a possibility that we may see a completely new regulation or completely different competition bill rather than an amendment bill? And if that also might affect other upcoming acts like the Digital India Act because of this ex-ante regulations?
Very, very good question, Tushar. And in fact, this is one of the, again, hot topics currently. We had heard from Commission as well on these points very recently and as late as last weekend. And it looks like the Commission is coming up with its own digital markets unit, similar to the UK. And it is looking at ex-ante regulations very seriously. And obviously, it is looking at the experience from other jurisdictions such as Germany and how it's shaping up. And now, obviously, we know in the European Union, there is the legislation itself. So CCI will draw from the experiences that these jurisdictions have. Certainly, they are looking at ex-ante regulation as an option. There is a lot of talk, not only from the senior members, but also at the junior level, where they are suggesting that this is something which is needed, perhaps not only limited to digital markets, but generally for dominant entities in the market and how they have a special responsibility to act in a particular manner on the market. So this is gaining a lot of traction right now. But in terms of mechanics, I believe that I don't see that another competition act itself will be, will come in. probably this the current competition amendment will go through certain changes, if at all. And those also perhaps depends on how the Parliamentary Standing Committee looks at the requirement of ex ante regulation. But otherwise, knowing how the CCI has functioned over the years, it looks like that through regulations they are likely to bring in ex ante regulation rather than going through a complete overhaul of the legislation itself.
Okay, thank you, Prateek.
Great. Well, thank
Yeah,
you.
Jay,
Thank you, Tushar.
Did you have a follow-up question, Tushar? Great.
yes, Jay, I just had a follow-up question on this. Prateek, how will the ex-ante regulations manifest in the upcoming competition amendment bill? So, are there any kind of formulas or principles that the CCI might consider, to assess how the companies would behave in the future while they are looking at it from today's perspective? And now that the Parliamentary Standing Committee on Finance has been rejigged, will there be a delay in submitting the report ahead of 90 days? Because the deadline for them to submit the report is mid-November. Would that be?
Frankly speaking, Tushar, it's still early days. The mechanics are not very clear how ex ante regulation is likely to manifest here in India. But as I said, it is more likely that through regulations, CCI will come out with certain rules of engagement on that front. They have a separate sort of internal department, just like they have the antitrust division and the combination division. They are likely to have a division looking at digital markets. So that is certainly going to be there, but there's not a lot out in the public. And even I think Commission is still working on it and looking at mechanics. In terms of the amendment bill, yes, it is likely to be slightly delayed behind the timelines that we expected previously. Probably now the report is likely to be out only towards the end of the year. So that, and more realistically, I believe that this is going to be pushed to the next year, and that's when we can perhaps see the amendment bill being enacted into law.
Okay, thank you so much, Prateek. Thanks a lot.
Thank you.
Thank you. And with that, we've come to time. Once again, every time we do one of these sessions, and I think we've done 7 this year, we really understand that we're talking with true experts. And I want to thank the Katana Company team, not just for today, but for providing us legal expertise for the entire year. This is our last roundup for the year. We will restart this next year, I hope and assume. We're always taking feedback if you have ideas or topics on how to improve the presentation or the information exchange. With that, I really want to thank Prashant, Shobit, Mohit, Anusha, Sadupta, Pranjal, and our moderator, Paku, but also Ravina on the back end and the entire KCO team that just spends a lot of time putting together this information. As I said in the beginning, we are recording this. We will make this session available. We will make the slides available as well to USIBC members. And with that, I want to thank everybody for their time. I want to wish them a happy, a healthy, and a wonderful Diwali from USIBC. We appreciate all your support and time and attention. I think time and attention are the most important things. So with that, I thank you and bid you all a farewell for hopefully a long weekend. Thank you all and talk to you soon. Signing off.
Bye.